I think we've got four options with the second injury fund as to address its financial condition. One, we can do nothing, and that's pretty much what we've done for about the last 4 years is nothing, and watch the second injury fund slide further into insolvency. But it is an option. I think it's not a good option because it says very little for our treatment of truly injured workers. And I think probably the end result of doing nothing would eventually, we'd find the second injury fund in court, and we may eventually have a judge or a group of judges telling us what we must do with the second injury fund. Not a good option. The second option would be to abolish it. I think the 22 other states now have abolished their second injury funds. Other states have drastically altered their second injury funds because they were experiencing the same problem we have. While our insolvency may be into the tens of millions of dollars, other states have gone into the hundreds of millions of dollars and just thrown up their hands and said, that's enough, we quit. I think the danger in that is that truly injured workers would, the only other place for remedy would be workers' compensation insurance, and then we'd have a load on workers' comp. A third option that other people have discussed with me is to return it to its original intent, to be a veterans-only program. I think that's an attractive idea, but I'm not sure that is all that realistic. The fourth option, which I'm going to discuss today after I run through a very brief history of the second injury fund, is to do what House Bill 522 attempts to do, and that's modify House Bill 522. For the benefit primarily of your freshman members, Mr. Chairman, and as a quick review for the more senior members, the second injury fund started in 1943 as an enticement to employers to get them to hire wounded veterans who were coming back from World War II in sort of a fragile condition, so to speak, for fear that they would be injured a second time on the job and drive up the employer's workers' compensation premiums. So the second injury fund started in 1943 with a surcharge on workers' compensation premiums. That surcharge was capped, I think, in 2005 at 3%, and it's still at 3% today. From 1943 until 1985, the second injury fund paid out a grand total of $25 million. For about the last 3 or 4 years now, we haven't been able to keep $60 million in it in a year. And it is, I believe last year in 2008, the Attorney General was asked twice to define insolvency by the Chairman of the Workforce Development Committee, and also tell us what happens if the second injury fund does become insolvent. Those two letters went unanswered. So now we're still trying to figure out how to get the second injury fund moving away from insolvency, and that is the purpose of 522. I have no illusions. I don't think 522 is a permanent fix for the second injury fund, but it is a worthwhile attempt to move it up toward a positive balance. I don't think we need to get it up to $1 billion fund or anything like that, but I do think that even if 522 passes, I think it's still going to need to be addressed 2 years, 4 years, sometime down the road.
But I just wanted to be here today to testify in support currently of House Bill 522. We appreciate the work of the legislature over the last year to address the Shamwell decision and some of the issues that were at play there, and we think that's one step in the right direction to working towards solvency of the fund. We definitely look forward to working with the chairman, members of the committee, the sponsor, and also other interested parties to try to work to a spot where we are trying to better the solvency of the fund, making sure that it's taking care of the true intent of the workers that it's intended to protect, as well as working to monitor that impact on the businesses that pay in there. And I think that was mentioned previously in the testimony regarding the surcharge. So we look forward to working with all parties and try to get this to a point that's helpful to the fund, both in the short term and also working towards a long-term solution.
I'm a blue-collar worker. I'm proud of it. but I can tell you it is important to have this type of coverage available. I would say it's probably more important in the industrial manufacturing environment than almost anywhere else because of, one, the amount of risk and inherent danger there is while working in such a heavy industrial environment, and number two, the fact that these jobs are so portable that, and I want to speak a little bit to also the desire to maybe raise this rate to a 4 or 5% ceiling. I guarantee you if you do that, you will drive more of these types of jobs out of the state of Missouri. I've personally witnessed it happen in other states, not with my own employer, but with others as well. I mean, the more you raise the cost, especially on large companies that employ a lot of people, that pay good paying wages, that have wonderful benefits, the more you add cost on top of all of what they already are providing for employees in this state and in this nation, the more you are pushing not only those jobs out of the state, but out of this country, because manufacturing jobs are portable. They're not like some service sector jobs and others where it's hard to move those out of state if it's a service you need to provide. My personal experience has been with an injury that I incurred about a year and a half, 2 years ago. It was just a little cut on my finger. I went to nurse. Well, actually, I was examined by the doctor on site, by my employer's doctor, and I was treated by a nurse. And that afternoon, I was back to work. I mean, it was a pretty good cut, a lot of blood, but it wasn't going to stop me from doing my job. The point I want to make was that within 2 weeks, I received a letter from a firm that I believe was a firm that would represent me before either the workers' comp organization or the second injury fund. It was a form letter. It had a response envelope in it, and it was literally encouraging me to file a claim. And if there was any way, shape, form possible that I could attach a previous injury to this injury, that we would definitely go after the second injury fund because of the ability to get larger. Well, these will be my words now, and not theirs. But the fact that it is much less proscribed. There is not a matrix for injuries versus numerations. I mean, it literally is how well is your lawyer able to work with that ALJ, and your number could be anywhere from this number here all the way up to $65,000. It is being abused, and I'm not exposing corruption here. What I'm trying to expose to you, though, is there's a culture that exists that I've worked in for over 30 years. That if you can find ways to take a cumulative set of injuries, and you're nearing retirement anyway, because it's always been bad for you to file a claim as a young employee because it did not reflect well on your work record. But if you're nearing retirement and you're less concerned about whether or not you're going to be employable should you lose that job, and you can get a $40,000, $50,000, $55,000 paycheck just before your retirement, hallelujah. I mean, it's just a bonus check for your retirement. I don't call that corruption because we have a system that supports that effort. It is a culture. I think this bill addressed some of the problems, and a lot of you have said your concerns about not going after long-term solution. I think this is a great first step. This bill will be an opportunity to maybe here and up on the floor address some of these other issues, but your problem is process.